Good morning. This is Rufus, your friend Rufus again, and I wanted to do a part 3, final part 3 of the Supreme Court original jurisdiction. My computer messing up. Anyway, I wanted to read a little bit of the case law, Chisholm versus Georgia, in which the opinion given by Judge James Ordell in 1790, what's the year is that? 1793 to 93, let me see. 1777. That's when Thomas Jefferson was president. But the case law is still good. It's a fresh case law. And this deals with Supreme Court original jurisdiction when dealing with the states. And I wanted to further elaborate on it. I wanted to show you guys, because like I said, I'm not just going to come on here talking. I researched. I researched deeply, and this case law, it states that when it comes to the states, suing the states, the Supreme Court has original jurisdiction pursuant to Article 3 of Federal Constitution. I just want to show you this. I'm going to read it. Okay, notably, Associate Justice James Ordell, who later filed a famous dissenting opinion in the U.S. Supreme Court decision in Chisholm versus Georgia, heard the arguments at the district court level while discharging his duties as a traveling circuit judge in the early days of the U.S. Supreme Court. Justice performed the double duty of deciding cases for the nation's highest courts, riding circuit to hear cases in the particular jurisdictions they were assigned. In his opinion, for the circuit, Ordell dismissed the suit for want of jurisdiction, if any, had jurisdiction over the dispute. Ordell said it was the U.S. Supreme Court because Article 3 of the Federal Constitution gave only the Supreme Court original jurisdiction over all cases in which the state is a named party. It may fairly be presumed Ordell wrote the circuit court that the several states thought it important to stipulate that so awful and important a trial court to which a state is a party should not be cognizable by any court but the Supreme. Ordell's conclusions were not challenged that's important. Ordell's conclusions was not challenged when the Supreme Court heard Chisholm's under its original jurisdiction. One reason Ordell's lower court decision was not challenged in the Supreme Court is that Georgia would likely have been the only party objecting to it, and Georgia refused to hear before the nation's highest court after Chisholm refiled his lawsuit there. Georgia feared that by making an appearance at trial, the Supreme Court would deem that appearance consent to the court's jurisdiction over the dispute, something Georgia denied that the court had power to exercise. Nonetheless, in the public pronouncement, Georgia governor made it clear that the court had no jurisdiction, but the state had not consented to the suit in its capacity as independent and sovereign government. Okay, I just wanted to, highlight on that a little bit. I'm just, the point I'm trying to make here in this part 3 video of the Supreme Court original jurisdiction in which the state has a party is that the Supreme Court has a responsibility to keep the states in check. And when state officials cross the line, you have an issue. Notably, mostly state attorney generals who represent the states. So, but I had an issue, dealing with state, and I'm still fighting that issue right now. But the point I'm trying to make is that the Supreme Court, like I say, they turned down a lot of petitions, but they, under the Constitution, they're not supposed to turn down petitions dealing with the state. If the state is a named party, that's the language stated in the Constitution. If the state is a named party, they're not supposed to turn down petitions. So I hope someone can benefit from this. I'm dealing with this right now, and Supreme Court, I have much respect for the Supreme Court, but they don't do enough. They don't do enough, in my opinion. This is just my opinion. I have a right to my opinion. But to me, they don't do enough with these states because I wouldn't be going through my personal issue dealing with the state I'm going through now, if the Supreme Court did enough. Or, well, they shouldn't have to, because there's other case laws in place to keep the states in check, like Bennett versus Arkansas, and that's a powerful Supreme Court case law. But anyway, when the states cross the line, and disrespect citizens' constitutional rights in this country, particularly 14th Amendment rights, Fifth Amendment right, due process. Well, 14th Amendment and the Fifth Amendment both have due process clauses. Citizens have a right to due process and equal protection of the laws. And that's under the Constitution. When the state crosses the line, the Supreme Court, you can go directly to the Supreme Court and sue the state. So with that being said, that concludes my Supreme Court original jurisdiction. I have a couple more cases. I have another case law too, Ex parte Young. I'm not going to read that one. I like this one, Chisholm versus Georgia. Because it's a little bit more language in this one. But Ex parte Young is another case law in which the Supreme Court had original jurisdiction over a state issue. But anyway, you guys, I love y'all. God bless y'all and have a nice day. Peace.